It's a serious case. And so I got to protect society, unfortunately, because you're not choosing to. About to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Good morning, sir. Are you John Jones?
Yes, ma'am.
Mr. Jones, this is difficult for me because based on your behavior, honestly, I don't want to give you I don't want to go along with anything. But it sounds like if Mr. Coleman has discussed this with everyone and understands the underlying facts of the offenses, what has been going on in a jail, I'm going to go along really only because I trust him to the extent that I do. Do you understand?
Yes, ma'am.
In cause number 25, DCCR 0523, you're charged with a first-degree felony offense of murder, and that's from April 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am. And
are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged. All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25, DCCR 0523, find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 2431, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1352, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in that case. These three cases will run concurrently, which means together at the same time. You will pick up another charge as quickly as you do anything else stupid in our jail or here. And if you think it's funny to ask my bailiff what he would do if you tried to get his gun, you're going to end up with another charge. I know about every single thing you're doing. Don't think there's anything that you're doing out there or here that I don't know about. He could press charges on you right now. But honestly, we're ready to get you out of our jail because you've been such a menace to everyone out there with what you're doing. And let me tell you, when you get to TDC, you think you're funny, you're young, you're not going to get away with what you're getting away with here in TDC. There's some bigger, badder, worse people than you there. And also, if you think you're going to make parole by acting how you've been acting, you're not. I would bet money today that you're going to be in our prisons for 35 years because you don't know how to behave. Prove me wrong, and that would be great if you figure it out and start learning how to mature and act like a normal human being like the rest of us. But my money is on you not doing that. So I wish you'd prove me wrong because everybody that has to deal with you, they're just doing their job. Yep, I think I would.
On that call, Ms. Shakita Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the record will so reflect?
And Ms. Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the court orders?
Yes.
And each one of those in detail is gone over with them so that they understand everything that they're required to do.
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake?
She was advised at her intake and at a TTM at the Milton Center in person.
Okay, and describe for the court what a TTM is.
A treatment team.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were in fact the majority of those things intended to help her?
Yes. The main thing is her mental health. She refuses to address that. We've made appointments for her with Spinal Tap, and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services. And she maintained contact with the victim in the case. So.
Ms. Cole?
Just briefly, during your supervision of Ms. Atkins, was you able to supervise her at points when she was on her medication and not on her medication?
The entire time she has not been on her medication.
So she's been on medication this entire time?
Yes, sir.
Supervision. Okay.
Anything else?
Nothing else.
And mental health help. So, Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment.
The judge spots a major problem, a positive cocaine test after earlier negatives. Under U.S. court rules, a violation can trigger sanctions. Is his story enough?
In Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one, how many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems. I mean, some people do that. No.
Well, you obviously, we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be, what?
Evaluation where?
At Spinal Tap.
That's what I'm telling you. That's not, I don't have that. I'm not a psychopath. That is for.
It's psychopath. Nobody's saying you're a psychopath, but you have.
It's called PASS program. I'm not a psychopath. That's what
That's not what it's called, and that's not the reason it's called that, okay? If you had gone to your appointment and talked to them, then you would know what that was for, and you would know that it was meant to help you so that you could get on medication, stabilize, and not have the issues that you've been having. I'm going to find that you previously entered your, okay, well, I don't believe you. I don't believe you. Ms. Cole would never say, go do something and not tell you where to go or help you get there.
No, she says she does not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health and the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to. About to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Mm-hmm. Okay. I'm going to find sufficient evidence to find you guilty, and at this time, I'm finding you guilty of injury to an elderly individual. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit. You will receive credit on that sentence for any time that you've been in custody.
I have a doctor's appointment and everything. That's what I'm
I've got 5 more years that I could add on to that.
Yeah.
I can give you up to 10. You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I went to the hospital and everything.
I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition because of the judgment entered against.
I don't have a gun.
I'm not, just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I don't have a gun, man.
Good, then you don't.
I'm to the wrong person. I'm Devin Atkins. I don't have a gun.
I'm required to read that to everyone.
I don't know what you're talking about. I don't have a gun.
Today's hearing is a reminder that what happens inside the courtroom can matter just as much as what happened before it. Sentencing is not only about the original offense, it is also about accountability, compliance with court orders, and a defendant's willingness to follow the law and respect the judicial process. In this case, Judge Raquel West emphasized that repeated interruptions and failure to comply with probation conditions only made the situation more serious. The hearing demonstrates how a judge evaluates not only the facts of the case, but also a defendant's conduct when deciding an appropriate sentence. If you enjoy real courtroom proceedings with professional legal commentary and detailed legal breakdowns, be sure to like this video, subscribe to the channel, and turn on notifications so you never miss our latest Judge Rackwell West courtroom highlights. Thank you for watching, and we'll see you in the next courtroom.
And that's where this courtroom drama takes a serious legal turn. The defendant admitted a violation, while the court was confronted with a positive cocaine test and concerns about compliance. Under U.S. federal law, violating conditions of release can justify revocation and detention when the required legal findings are made.